All right. Between everything that we've been doing all day today and the 5 minutes that we had in between, right? It kind of feels like that. All right, let's see here. We're almost on Zoom. Almost ready, folks. Okay. Lots of people today. And here we go. Okay. Hey, Mr. Stewart.
Good afternoon, Judge.
How are you?
Good, how are you?
Good. Technology so far is working. All right. Big difference between the morning and the afternoon, which is good. All right. Is Mr. Arias present? Mark Arias. Mr. Arias does not want to join us today? Okay. All right. Thank you. All right. Mr. Arias is here on a violation of state probation. The other judge in his case directed that he be held no bond. This court is also going to continue to hold him no bond. Thank you. Next would be David Augustin. Mr. Augustin. Let me just pull his name. Oh, Mr. Walter is? Walker. Oh, is he set for a plea this afternoon? Okay, that works. All right, and Mr. Augustin, just give me 1 quick second. I need to find your information. All right, Mr. Augustin, the court has reviewed your booking information, does find that there is probable cause. Your bond will be set at $2,000. In addition, the court is going to order that you have a no trespass at the 7-Eleven, which is located at 105 Carver Street in Immokalee, Florida. Okay? Thank you. There we go. Thank you. Next would be Tavian Dorsey. Okay. Okay. I'm ready. Yes. Is that correct, Mr. Stewart? Are there offers to resolve his cases today in order to allow this defendant to be released?
Judge, if I could have 1 second, I wasn't aware of that, but I can look.
If it wasn't sent by Ms. Woodley, I just received an email from her like about an hour ago, so I'm not sure if she needs to reach out to the proper.
Judge, there is an offer on his pending case.
Okay.
That's about all I can say.
It looks to me like, oh, I'm sorry, that's not the right one. There's one pending case for him. Yes.
We have 20 MM 1650 with an adjudication and $250 fine, and then 20 CT 1805 with a no valid with a withhold and a $150 fine.
Yes?
Not right now, Fabian, hang on.
2016-50 MM's an adjudication, a $250 fine plus all costs. And what was the other case number?
20 CT 1805
And what was the offer on that one?
withhold $150.
What's the other case? I'm sorry, 20 CT?
20 CT 1805. I only have the order revoking bond on 20 MM 1650. I didn't have 20 CT.
The other one, I think, was a citation. That's why.
Okay.
Are we doing the plea now? I'm sorry, Judge.
Oh, no, I was wondering whether the state was inclined to agree with Ms. Armpriester, and there was 2 plea offers that we would do at 2:15. Would that be accurate?
That's fine, Judge, if he wants to resolve those.
Okay. All right.
I mean,
So
we can do his first appearance still now.
yes, that's what I was thinking. All right, Mr. Dorsey, the court has reviewed your booking information, does find that there is probable cause on the charge of burglary unoccupied. The court will impose a $5,000 bond, $2,000 on the criminal mischief, and $2,000 on the petty theft. 5 plus 2 plus 2. 9. $9,000. I'm sorry. Is it a question for your lawyer? Oh. Sir, do you realize that the public defender is actually a lawyer? I mean, they graduated from law school just like I did, just like every other lawyer, and passed the bar exam just like every other lawyer. So the public defender that's helping you is actually your lawyer. So you'd like to speak with her?
Katie, and either myself or Justina will be over to see you as soon as we can. Now's not the time. Please let the judge move on, okay?
Oh, okay. All right. Next would be Mr. Letchworth. Mr. Letchworth. Every day I've been trying to see Mr. Letchworth. He's refused to come in and visit with me. Oh. I just wanted to make sure, because it's the 3rd day in a row with this gentleman, I believe. Okay.
Because these are all added charges, Judge.
Right. Okay. All right. So with Mr. Letchworth in the booking, which is number 21-123, charges of burglary and grand theft, the court is going to impose a $10,000 bond per count. In addition, ordering that there be a no trespass at the Coral K Golf Center, I think it's called. I'll just say Coral K Golf. 2205 Tamiami Trail East in Naples. East Naples. And then on, let's see here. Next one, which is the burglary charge, booking number 21-124, will also be a $10,000 bond. And in that one, there will be a no trespass ordered at the extra storage, which is located at 571 Airport Road, Naples, Florida. In addition, the court is ordering that any and all firearms need to be relinquished within 24 hours of his release. All right, thank you. Mr. Levi, okay. Here we go. Thank you. All right, Mr. Levi, the court has reviewed his booking information. Also does find that there is probable cause. Do I have 2 on him? I only have. Yes, I do have 2 booking sheets on him. I thought I did. All right. With respect to booking number 21-145, on the battery, the court will impose a $2,000 bond. On the paraphernalia, $2,000. Resisting without violence, $2,000. In addition, the court is ordering no contact with Gregory Costa. And in addition, ordering no trespass at Pelican Larry's, which is located at 7785 Davis Boulevard in Naples, Florida.
Your Honor, he's also out on bond in 201496 CF, so we're asking the court to revoke his bond in that case.
Yes, the court will revoke his bond in that case. Let me just find it. Wait a minute. Do I have an order revoking bond on him? Hold on. Thought you got me one. Stuck to this one. Yep. All right, let's start with that. There's the order revoking bond. The court is also ordering that any and all firearms be surrendered within 24 hours of his release. And with respect to booking number 21-150, court does find that there is probable cause. On the possession of the firearm by a convicted felon, it'll be a $20,000 bond, and on dealing in stolen property, it'll be a $10,000 bond. No contact with Judy Johnson. And also a no trespass at 3731 St. Clair Shores Road, Naples, Florida. There we go. Thank you. All right. Mr. Oliva is done. That would bring us to Mr. Perry. James Perry. Here he comes. Good afternoon, Mr. Perry. The court has reviewed your information, does find that there is probable cause. With respect to the burglary, it would be a $5,000 bond, and on the petty theft, it will be a $2,000 bond. Court is also ordering no contact with Ibis, Urbina, Sanchez, and a no trespass at 4825 Whistler's Green Circle in Naples, Florida. Okay. Thank you, sir. Thank you. All right, that brings us to Mr. Planta. Good afternoon, Mr. Planta. You're here on a fugitive from justice out of Seminole County. The judge in that county has directed that you be held no bond. That will be the order of this court at this time. This gentleman, it says he speaks Spanish. So you do understand what I'm saying, sir? Okay. Understanding that everything here is being recorded, sir. Okay, what's your question? What was that? I'm sorry. Is that what he asked, was if you would get a public defender? Oh, yes, sir, this charge that's against you is out of Seminole County, so you'll need to contact an attorney in Seminole County that can assist you with this. The court can't do anything with your case here in Naples. We don't have jurisdiction, sir. If you do have a public defender, that public defender would be an attorney who practices in Seminole County, not here in Collier County, sir. Okay? You would not have an attorney here because the case against you is not in Collier County, it's in Seminole County. There is no bond. That was set by the judge that has your case up in Seminole County. The judge in Seminole County signed a no bond warrant. So if you want to address the issue of whether you can post a bond, you're gonna have to file a motion up in Seminole County, okay? Okay, thank you. There we go. Okay. Next would be Jose Velasquez. Mr. Velasquez. All right. Let me take a look at this one real quick. I did not have an opportunity to take a look at Mr. Velasquez's habeas. There's one I missed. Give me a second. Give me a quick second, sir. I apologize. All right, so you're here today for KPS warrant for a violation of an injunction protection against domestic violence. Court does find probable cause and set short bond at $2,500. In addition, you will continue to have no contact with Susanna Cruz, be deemed confidential, as also indicated in case number 20 DR 1847. The injunction is still in place, and now there is an additional no contact that is being placed by this court in the criminal case. And I'm also signing an order that directs you to relinquish any and all firearms within 24 hours of your release, sir. Okay? All right, thank you. The next person we have is Stephen Waite. Mr. Waite? All right, and Mr. Waite is here on a violation of state probation Widman Act that was signed by me yesterday, directing that he be held no bond. Court is going to continue to hold him no bond. Thank you. All right. Oh, did I give you both? Did I give you Marquis William too? I think I did. Yep. Next would be Mr. Marquis William. Mr. William, sir, you are here as a fugitive from justice out of Lee County. Lee County has indicated that you be held no bond. That will continue to be the order of this court, sir. Yes, sir. I believe that your ROR status was revoked yesterday, sir. That's what happened, if I remember correctly. I'm having a really hard time hearing them over at the jail. Is it like feedback or what's going on? Or is it just because I'm up here? Is your question whether the court will set a bond today? Yes, sir. There is no way we can resolve this today. No, because that case is in Lee County. And your bond was revoked in that case yesterday based on the new arrest that you have pending before Judge Foster here in Collier County in 21 CF 36. I will tell you that I contacted the judge up in Lee County directly to convey to her that I had in fact revoked your bond and to see whether that judge wanted me to set a bond, and the judge indicated to me that she did not. In light of the pending felony charges that you recently picked up here in Naples, it is completely appropriate to revoke your bond, which has been done in that case. If you would like to try to receive a bond in the Lee County case, you're going to need to file a motion with Judge Pollack. Oh. No, I don't have that case. This is out of Lee County, sir. You have new charges here in Collier for possessing paraphernalia and a controlled substance, which are set before Judge Foster. The case that I just brought you forward on was for the Lee County case, sir. Okay? All right. Thank you. All right. And then we're changing over, right? Thank you. Got it. Okay. So let's find this one next. All right. Where is he in here? Oh, it's a she, that's why.
Judge, we are going to need to go back to Mr. Dorsey, wherever he was located, for those pleas.
He was back in 31B. And looks like everybody else.
I mean, I just hope they don't take him back, that's all.
Right.
Naples Jail.
You guys ready?
We're gonna need Mr. Dorsey from 31 to come down to you guys. He's gonna enter a plea at 2:15.
Can we do that, or do we need to go back to the other room?
Or is he in quarantine?
He is in quarantine, you'll have to do it on that one.
Okay.
Okay. I didn't know how you guys are gonna frame him.
If he's in quarantine, will they let him out even with a plea?
Yes, they will.
They will? Okay.
Oh, okay, I didn't know
Okay.
that. All right.
All right.
Just let him know we're gonna need Dorsey, please. Thank you.
Who do you guys have available in that room right now? Is it the gentleman?
Rest of them.
I only see one person. Who's the gentleman that's right in front of me?
The gentleman here is Lardy, first name was Mustafa.
All right, Mr. Awardi, let's take you because you're sitting there. Mr. Mustafa Awardi, let me just find you, sir. Oh, there he is. All right, sir, the court has reviewed your information, does find that there is probable cause on each count. Each count will be set at $2,000 per count. In addition, the court is going to order that there be a no trespass at the McDonald's, which is located at 2886 Tamiami Trail East. Yes, sir.
I called the police and she came, she told me you wanna go home or you want to That's all about. I am charged because I come from Christmas.
Also with a count of marijuana, not more than 20 grams, and resisting arrest without violence. You have 3 charges, sir. And sir, that may very well be a defense for you to present at your trial. The purpose for today is for me to make a determination based on the information that I received, whether there's probable cause, which I do find, and also to set a bond to allow you to get out of jail and be able to discuss those issues with an attorney if you choose, or you can always represent yourself if you'd like to. But for today's purposes, your bond is set at $6,000. Okay? 6,000 total. Thank you. 2,000 per count, yes. Okay. All right. Do we have the females in there or Mr. Bub? I have Jesse Rodriguez, Aliyah Warden, and Kevin Bub.
So from here on out, Your Honor, Bub is a medical refusal, Rodriguez is a refusal, and Ms. Warden is also a refusal.
Okay, well, we can just handle those without them present then. All right, let's start with Mr. Bub. Find him. He's the first one in my stack. Mr. Bub, I'm going to recall tomorrow. I attempted to get a hold of Judge Sweat to ask Judge Sweat whether I could set a bond in his case, and I was not able to reach him. So I will recall Mr. Bub's case tomorrow on the issue of whether to set a bond. So this will be reset to tomorrow. Okay, thanks. The next one is, where's my list? There it is. Let's go to Ms. Rodriguez. And, all right, with Ms. Rodriguez, the court has reviewed her information, does find that there is probable cause. On the felony possession of drugs, it'll be $5,000. On the marijuana, $2,000. And on the narcotic paraphernalia, $2,000.
Your Honor, she's also on probation on a felony case from the East Coast, and I did provide the court a Whitman Act warrant for her.
Okay. Yep, we'll grant that Whitman Act on that case. And that would be Broward County 16-2039 CF and 17-814 CF. Okay. All right, and next would be Aliyah Nicole Warden. And with Ms. Warden, court has reviewed her information, does find probable cause. Her bond is set at $500. time. There we go. All right. Then, who do we have next? Then it says same room, once it's cleared out, to call Mr. Blank, Mr. Keller, and Mr. Tavares.
And they're all here, Your Honor.
Okay. Oh, wait a minute. I have Henry Savard. Where is he? Oh, he bonded? Thank you. All right. All right, there we go. Okay, let's start with Mr. Blank. All right, Mr. Blank, you are here as a fugitive from justice out of Lee County. The judge up in Lee County has indicated that you be held no bond. That will continue to be the order of this court, sir. So if you want to try and get a bond set, you have to do it in Lee County. You'll have to do that in Lee County, sir. The case that you have filed? Okay. So you can fill out the form, but your case is going to go in Lee County, sir. All right, thank you. And then next we have Mr. Keller. Okay.
Mr. Keller is Terry, it's your attorney. I'm gonna come visit you on Monday. You and I are gonna have a visit. Don't say anything else on the record right now, because it's for something totally separate, okay? Just listen to Judge Nicola. You don't have to say a thing right now.
Okay,
Terry,
thank you. That's okay. For today's purposes, I will appoint you. It's only for today. Sir, you're here on a warrant out of Pinellas County for failure to appear. The judge in that case set bond to $2,000, which is an interesting amount, but that's the amount that was set. $2,013 on the fugitive from justice warrant. That will continue to be the order of this court. Okay. And then we have Calvin Tavares. Good afternoon, Mr. Tavares. Mr. Tavares, you're also here on a fugitive from justice out of Lee County. In that case, the judge in Lee County set your bond at no bond. That will continue to be the order of this court, sir. So if you want to try to get a bond set, you have to make application in Lee County. Okay? I can't tell you how to do that. You're going to need to speak with an attorney, sir, or somebody who can assist you with your matters in Lee County. I could just tell you that the case is out of Lee County. The case number out of Lee County, I had it. Let me look at it. The case number is 20 CF 657.
And the name of the assistant state attorney?
I have no idea. I have the case number and the warrant that indicates that you're to be held no bond. I'll leave that up to you, sir, to find out. Thank you. Okay. Here we go. Thank you. All right. I think that's everybody, right? Except for I have a plea. Looks like I have two, Mr. Dorsey and Mr. Dorsey now, Mr. Walker, and Ms. Page.
Judge, if we could continue Mr. Page to tomorrow, that was a mistake. He should have been on tomorrow.
Okay.
I'll visit with him at 3:30.
Okay. So Francois Page has two cases, 20 CT 2454 and 20 CT 1351. Those both are going to be continued until tomorrow afternoon at 2:15. All right.
Thank you, Thank you, Your Honor.
All right, sir, we're going to continue your matter to tomorrow afternoon to allow you the opportunity to speak with Ms. Armpriester, who's here, okay?
Frank, I'll be at the computer at 3:30 today for us to talk, okay?
Okay, thank you.
All right, see you soon.
See you tomorrow, sir. Thank you. Okay. What did
The
I
judge provided an order on a Widman Act warrant that was not on the docket today, but had been issued in error with regard to one case, Pedro Ivan Vasquez. Did the court get a copy of that?
I don't think so. I don't see it. The only thing I have in front of me is an order revoking bond for Mr. Dorsey. I don't see anything else. Did it go over to Jen?
I did. I can resend it.
Sure.
Who is the clerk in the courtroom? I'll send it to them.
Ellen, right? What's your
Ellen.
email?
I got her. Okay.
I can never remember your last name. What is your last name?
Gilbert.
Gilbert. I should remember that.
It was Joe switching over to 31, okay?
Judge, I did send it to Ellen. Basically, the Widman Act was issued on 2 different cases. It really only applies to one of them. So the order just quashes the Widman on the one case and keeps it in the other case.
Okay. Great.
And Judge, on Mr. Welker, I don't think he's going to be joining us today. He was.
I see him. He's right in front of me.
Oh, he is. Okay, good.
Yeah, he's here. Thank you.
Mr. Stewart, it's Miss Armpriester. He did still show up to court, so I'm gonna, as soon as I can, excuse myself to go outside and explain to him what you and I had talked about, but he's a man of his word and he's here today.
Okay. Yeah, I wasn't expecting him to be released prior to today. That's all.
A lot of times people get released mistakenly if they don't show up for court, so you're doing better than a lot of people. Well, now you are. So she wants a minute to speak with you before we bring you back. So I'm going to give her a minute to talk with you. And all right, we have Mr. Dorsey's back. You want to go ahead and talk to him for a minute, Mr. Dorsey? We need to have you review a plea form, sir. Let me take a look at the other one. Can you add 20 CT 1805 to the docket at 215? If not, if you
I did.
you did? How come
You
I-
have to refresh it.
Oh,
Are you in Smart Bench or Shuffle?
I'm in Smart Bench. That's why. I'm gonna just pull it up real quick. I've gotten so used to using it that I probably need to get used to using Showcase too, although they've said that they're gonna combine the 2 this year, is what I've heard, so. That's what they've said. You wanna speak with him for a minute? He's still reviewing the plea form, and I wanna look at his case first, if you wanna talk with Mr. Walker for a minute.
Have you a copy of the order that was signed for Mr. Walker, or can that start sending for me so that I can think concrete?
What's the order?
So that order that we had discussed, it inadvertently was signed by Your Honor, releasing Mr. Walker from custody.
Oh,
So
I don't remember that, but okay.
I just want to give him a copy of it, and hopefully today, should he elect to accept the diversion, he'll just have the paper copy.
Okay.
Then I can have a tangible item. Thank you, ma'am. Okay, you're on the outside.
All right, let's see here. Okay. Okay. I'm looking at the wrong thing. Okay. You have 7? I'm impressed. I have 1. I can barely keep up with her. Wow, that's awesome.
We're on mute, so no one hears. I have a potential.
Do you?
Yep.
Good. Because I was worried about today. I was really, really
Now
worried.
I have it.
Okay, thank you. Thought you might be falling down on the job, Joe.
Now I have it.
Okay, good. All right, let's see.
Katie, you need me?
Ready for 215 next?
Yes, we're a little bit delayed. We're almost there.
Waiting for the PD to come back in. You want to do him first?
Judge, may I approach closer so Mr. Stewart can hear me?
Sure.
Your Honor, hearing our prisoner on behalf of William Walker, 20 2090. Your Honor, he was released accidentally from custody yesterday. Pursuant to an order that released him from custody, it states that he must sign up for diversion within 10 days of his release. As yourself and Mr. Stewart are aware, I've been trying to meet with him. Why I wasn't able to meet with him today is because he was released from custody.
Okay.
After meeting and conferring confidentially with Mr. Welker and having had conversation with the alleged victim in this case, Judge, he's homeless. He doesn't have the funds or the means to comply with diversion. He lives in his vehicle that while he was in custody, the alleged victim in this matter wrecked. So if we were to accept what has been executed on the order for diversion, it would essentially, he's setting himself up to fail by accepting it because he can't afford it.
Okay.
However, I would like to, at this time, just given the posture of where we're at, he is here. He's obviously honest. He's been in contact with me, so is his wife. If we could somehow vacate this order, still have him released ROR, so that I can try to, one, reach out to the people in North Carolina where he would potentially be going to see what the cost and expenses of any classes could be, and to, again, speak with the alleged victim in this matter and perhaps set it for an appropriate bench trial.
Okay.
And speak with Mr. Stewart about that. The only concern is Mr. Walker certainly doesn't want to go back in custody. He has no priors, Judge. It's just he's dirt poor and homeless and has nothing to offer the court but his word that he will show up.
I remember this case from yesterday. We had a conversation about having some classes done when you went back north, and that everything could be transferred back up north so that you could head up north, and that I don't remember all the details of it, but everybody had agreed on the record that a good resolution of this was to let you out of jail, give you 10 days to sign up for diversion. You'd be able to go up north and do the diversion up north. That's what
Mr. Stewart and I were discussing. I didn't realize how poor and destitute my client was, and I also didn't realize when the alleged victim phoned me and said she was in a car wreck, that she wrecked essentially his home where he lives. So it's a change in circumstances, and I also did tell the court and Mr. Stewart that I needed to speak with him, and this was one of those details I gained by speaking with him, that he's too poor to pay for diversion.
Okay. Mr. Stewart, what are the state's thoughts on this?
Well, Judge, the issue is the court took the order back on Monday and signed it.
I did. And I remember it. I mean, I remember it being a very unusual resolution to the circumstance.
But he had not agreed to that yet. So that's why that was premature.
I guess that's not what I understand. I guess I thought I understood that he in fact was in agreement with it, that it was something that everybody was on board with.
He had wanted more time to speak to somebody, and that's why we had rolled it to today. But nonetheless, I mean, I'm not going to ask the court to remand him. He can do diversion. I've spoken to his wife about it. She thinks it's possible. He does not have to pay because he's indigent to get into diversion. He just needs to find a a class that is comparable to Batter's intervention program wherever he goes. And if he completes it, the case will be dropped. So I guess the only option at this point is to strike that language that he sign up within 10 days because he did not agree to that.
Okay.
As part of the release. And I guess we'll see what happens where the case goes. But I mean, in terms of, a trial or victim cooperation, I mean, there's an independent witness that saw everything. So, I mean, that whether the victim's cooperative or not, it's still a, fairly provable case.
I understand. Is there any objection to amending the language, and I'll walk down with Mr. Walker to diversion today and see if there's anything that I can assist with in getting information for the cost. He just doesn't want to set himself up to fail, but I'm sure there's no issue with signing up today.
I'm just going to tell you, I just decided while everybody's standing here and telling me how expensive it is to type in Batter's intervention online class. Online court classes, Batter's intervention, $5 a class. Court-ordered classes, $5 a class. I'm seeing stuff on here that's showing that there are classes on here, online 26-week classes with funding that are $5 a class. I mean, I'm looking at page after page after page.
Those are not diversion approved classes. You're correct, Judge. They do
Okay.
exist, and a lot of times shelters and other community organizations put them on. We're not saying he can't do it and he's not going to do it. We're
Okay.
just saying there's a chance that this very poor man may not be able to complete this within that 10-day frame. That's all.
We're not saying he has to complete within 10 days. He just has to sign up within 10
I
days.
understand, but Mr. Walker, being a man of his word, does not want to say that he will sign up for something that he fears he may not be able to do. And
Okay.
that is the concern he wanted me to bring to the court.
Well, if he can't do it, let's say that he goes into diversion and he can't do it. And he says, Ms. Arnpriester, I tried it. I can't afford it. Then the next thing that'll happen is I'll get a notice that he failed out of diversion and he's going to go on to another docket. He's going to go back on a pretrial. That's what'll happen. And then we'll be back in trial posture. You don't have to do it. If you don't want to do it, I'll withdraw the order. We need to get you sworn in, sir. It's okay.
Right here.
I'm not going to put you back in jail. So just deep breath. You'll be fine. You swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So first of all, let me tell you, sir, I did not understand when I signed this order that everybody wasn't in agreement. I thought you were in agreement on the diversion. But now I just want to know, what are your concerns? Yes. Okay. Don't tell me anything about your case, though, okay? I understand, but you can't tell me anything about your case. My big concern right now is, what do I do with your case? Do I withdraw this order that allows you to do I withdraw the order that says that you're to sign up for diversion and put you on another docket? Or do I give you the opportunity to go? Do I give you the opportunity to sign up for diversion, talk to the people at probation about whether one of these $5 classes would work for you? I'm not saying she thinks it will. You got to check with probation, the probation department downstairs. If you want me to bring this back tomorrow for review to see, I can do that. It is something you can do online. If you just have a phone, that might make it difficult, because you're going to need to have internet access or appear in person. I think it's a virtual thing. Yeah. Yes, sir. It looks like some of these are virtual. A lot of classes right now are virtual because of COVID, sir.
Judge,
I'm more than happy to withdraw anything I did on Monday. I just want everyone to be comfortable.
I'm just in a bad situation. Here's my drunk driver, had no insurance, the home, my business, and the COVID, and my wife's OCD, and the water situation is within an hour and a half. I bought 22 cups of hot water. She cleans with it, and she pours a gallon of cold in it, but she forgot to pour it on it. She poured it on my hands. I didn't mean anything. Some of the stuff that I said or whatever. I've always been good to my wife. My wife suffers with a headache. She has chronic congestive dizziness. I take care of her. That's why I can't find the work. I worked for myself all my life and I was able to, but after I lost that, now it's hard to find employment where I can take care of her. my car, she wrecked it while I was in there, her nurse is real bad, she has panic attacks, and blood stuff, and I have not enough to take care of.
Okay.
And I worked hard all my life up until this happened. I had a business, a successful business. I used to live 4 houses for Johnny Cash. I'm not boasting, but I'm saying I was blessed. And after the accident, we lost everything we owned. And this is just another burden. I hate to tell, I've been from the work, I hate to tell somebody something that I could not do.
Okay, I just need to know what to do today, because I have another gentleman who's waiting to do a plea.
Your Honor, there's only really one thing you can do today. If he's not going to be remanded, then the portion of the order that states he has to sign up within 10 days needs to be struck.
Okay.
And the case just needs to get set on a pretrial conference. And then if he's signed up for diversion prior to that date, then it'll be off the docket. And if he's not, it'll remain in a trial posture.
Sounds good. Let's do that. Can you print that order for me, Ellen, that I signed? It'll be set for February the 11th at 9 a.m.
Judge, we need a domestic violence pretrial date.
Oh, I'm sorry. I don't have my calendars in front of me, do I? Thank you.
Presumably that's the 8th.
I think you're right. I think it is Monday the 8th at 9.
But it'll be 10 o'clock for a pretrial.
10? Thank you. It's funny, I almost grabbed my calendars this afternoon. I was like, I'm not gonna need my calendars. Why am I gonna grab those? Yes. It would have been signed by me January the 4th, order releasing defendant. That's what I need. Because what I'm gonna do with this right now is I'm gonna write amended order.
What's the date?
It's going to be February the 8th at 10 o'clock. And I am striking the language that says you must sign up for diversion within 10 days. The only thing that this amended order now says is that you're released on your own recognizances and that we have lifted the no contact order with the victim. And I am changing the date from the 4th to the 7th. And there's our new order. It's a little bit,
I'm sorry,
yes.
it's actually Judge Adams.
Oh, it's not mine? All right, well then it needs to go to Judge Adams. How did I end up with it then?
I think it was probably on your DD hearing, which is the arraignment.
Oh, okay, all right.
Judge Adams' pre-trial would be February the 22nd at 10 a.m.
February 22nd at 10 a.m. with Judge Adams. And if you guys get something worked out in advance, great. It might be beneficial to you, sir, to go downstairs, talk to probation, talk about that deferred prosecution agreement, see if you like it, and see if one of those cheap classes will work for you. That option is still available to you if you'd like to do that, okay?
Just wait, you'll get a notice.
Okay.
It's online.
I need to take a break for a minute because I need to make a phone call. I told Jen I had to be out of here by 3 today. It's not going to happen. And I'll be back. Oh, sure.
Cheney, we're almost there, Cheney. We're almost there.
Do not leave without going down and talking to the person. Not today or tomorrow. I've got 100 other people on your boyfriend like part, but there's no conversation. It's fair, this is how you do it. I know, and it's not that I'm not sympathetic, but what do you want me to do with that? Go talk to your, but we have to jump through these hoops. At the end of the day, they don't know.
Yeah.
But go talk to your brother and see what you should do.
Thank you.
Just
Just had to make sure that I had to make sure I had a backup plan. That's what happens sometimes. We're standing now. Are you supposed to be standing?
When you come in, I am.
Not all the time. Nobody said all right. So you can sit.
Is this for him?
Sometimes I don't hear Joe and I just sit down and I forget people are standing. All right. All right. Deep breath. That's what I do. I look at the thing that every once in a while tells me to breathe and I go, thank you, because sometimes you just need to take a breath. And she's gone again.
They may need hand sanitizer.
Oh, I think I might need some hand
Oh,
sanitizer.
no, I know, no,
What?
I was self-work.
What do you mean, look?
Someone told you? He didn't put any on his hands.
I know.
Somebody already ratted out our plan?
What? What do you mean? Look.
Tommy told.
What's wrong?
I don't want any. I'm good, I didn't touch anything, I've been calling my own.
He totally ratted. I know it had to have been him. Hi, Mr. Dorsey, we're ready for you. Are you ready? Sorry for the delay. Do you have questions about your case? If you do, you have to ask your lawyer.
Vivian, I'm covering this plea for Justina. These are the same offers that you had, the adjudication and a $250 fine, and then a withhold. These are for the old cases, not the new one.
The 2016 50 mm is for carrying a concealed weapon. That's the one that's going to be an adjudication with the $250 fine and costs. And the 20 CT 1805 is the no valid driver's license charge, which would be a withhold of adjudication, $150 fine plus all of the costs. Do you understand that, Mr. Dorsey?
Well, the other thing, Tavian, is you can fight your felony and the judge can revoke the bond and then you can still show up with a license, but I'm not sure that will have any impact on the changing of the plea. If you don't want to go through on this plea, what would happen is the judge would revoke the bond and then you can continue to fight the cases, but you'll be held no bond on them.
Hold on. Let me look at this one. Oh, that's not it. 1805. I had a question on that too, Mr. Stewart. I actually looked up his driver's license because it looked like he had a pretty clean driving record. And it looked like he was suspended because he just owed some fines. So I guess the question would be, in case number 20 CT 1805, if this gentleman was able to get a valid driver's license, would the court, would the state still be inclined to make the same offer, or would this be a case where the state would dismiss the charges against him?
Well, Judge, previously I would have said we may dismiss, but based on his new felony arrest, I'm not sure that we would.
Okay. Did you hear that, sir? One of the reasons why they're seeking that there be a fine and some court costs in your no valid driver's license is you picked up some new charges. And the state attorney's office was planning today, in light of those charges, to ask me to revoke your bond in both 2016 MM and 20 CT 1805, which would mean that you would sit in jail no bond until those two cases were resolved. So you're being offered a resolution today to resolve those two cases, but you don't have to accept it. We could always set you for another date, on those two cases. But in case 2016 MM, I would be inclined to revoke your bond in that case. No, you have a bond in the new case. The new case I set at 6,000, didn't I? Can't remember. Let me look. I don't even know what it even said. Hold on, Mr. Dorsey. I can tell you what I set your bond at. I set your bond at 14,000. 10,000 on the burglary, 2,000 on the criminal mischief, and 2,000 on the petty theft. So you can bond out on the felony. However, if you do not want to resolve your misdemeanor cases today, which you certainly do not have to, I am going to revoke your bond in 2016 50 MM, and you may decide you want to resolve it tomorrow, and that would be fine. If you want to have 24 hours to think about it and talk with your public defender, I am more than happy to roll this to tomorrow and take a plea from you if you want to do it then.
Mr. Dorsey, I told you someone would come talk to you about the new case later, not now. These are for the 2 cases to resolve. I thought I was very clear about that. So do you want to plead to the 2 former cases or not? Because you're wasting the court's time.
Yes, sir? You do want to enter a plea today? Okay. Has he been sworn in? Yes? Okay. And has he had the opportunity to review a plea form and sign a plea form for both cases? Are you sure this is what you want to do today, Mr. Dorsey? Because as I said, I'm more than happy to consider it tomorrow. I'm getting a little bit to the point where
I'm just gonna ask that the bond be revoked.
yeah, that's what I'm doing. I'm becoming extremely uncomfortable with accepting the bond right now in light of what's going on with his body language, with his questions, with everything. I am more than willing to consider a bond tomorrow. To consider a plea tomorrow if it's resolved. He needs somebody to talk to him to explain everything that's going on in light of the new charges, in light of the old charges. So that's what we're gonna do. All right, court is revoking the bond in 1650 mm.
I know that the way she can address it.
Okay. If she talks to him tomorrow morning and, but I think he's confused and that just like the gentleman this morning who we figured out didn't speak enough English to be able to understand the plea. I don't think this gentleman understands enough about what's going on with all of his cases to make me feel comfortable taking a plea for him today. Okay. But I appreciate it. All right, Mr. Stewart, thank you.
Okay, thank you, Judge. Take care.
You too.